Major breaking news. We had oral argument today in the United States Supreme Court in the Cargill versus Garland ATF case over the ATF's bump stock ban. This is a major argument and went on for over an hour. There's a lot to discuss here. I'm going to give you the highlights today, and then we're going to have to break this down in further videos down the road. The bottom line is I think this is going to be a very, very close call. We do have some big takeaways that we're going to get to in about 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarm, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, major argument today, over an hour long, in the United States Supreme Court. The attorneys from Michael Cargill against the ATF and the Solicitor General's Office of the United States, Joe Biden's group. Big fight over whether or not a bump stock is a machine gun, as that term is defined by federal statutory law, specifically the National Firearms Act. The code is 26 U.S.C. 5845B, which defines machine gun as a weapon which shoots or is designed to shoot automatically more than one shot without a manual reloading by a single function of the trigger. The statutory fight as to whether or not a bump stock is a machine gun, as defined by the statute, focused today on whether or not adding a bump stock to a semi-automatic rifle somehow made that rifle, that weapon, automatically shoot more than one round, and or did this somehow cause the manual or automatically fire in more than one round by virtue of a single function of the trigger? We're going to get to these statutory fights in 1 second, but the big picture is this. As you may recall, for many years, the Bush administration, that's George W. Bush, the Obama administration, even Dianne Feinstein, a Democratic senator, all basically took the position that bump stocks were not covered under the definition of the National Firearms Act's definition of machine gun. Then you had the Las Vegas shooting with Stephen Paddock in 2017 during the Trump years. And then in 2018, the ATF decided to go out and basically expand the definition, arguably, of machine guns under the National Firearms Act, which was enacted in 1934, to encompass bump stock devices, which again, when added to a semi-automatic rifle, the argument was that made that weapon a machine gun. Now, this was not done by Congress. This was done by the ATF interpreting how they define machine gun and how they interpret what constitutes a bump stock in this context. Now, they gave rise to a series of lawsuits, and in March of 2019, if you possessed one of these bump stocks, you became a felon under the National Firearms Act. That's the reality of it. Now, here we are in front of the U.S. Supreme Court, and what is going on? So to make a long story short, this is going to be a very close case because it's laser focused on statutory interpretation. Now, so again, the issue is, did Congress enact the statute? The answer is obviously they did not specifically enact a statute involving bump stocks. And by the way, there's good reason for this. I don't want to get into a defense of Trump in this particular video per se, but the reality was there was talk on Capitol Hill about redefining what the 1934 definition of machine gun meant, and there was great concern that they would change the law and expand the definition of machine gun such that not only would we have an issue with bump stocks, it might cause a lot of problems with ordinary semi-automatic firearms, and there was concern about doing that. So as a consequence, to avoid Congress acting and trying to legislate bump stocks, a bump stock ban, and trying to come up with language that could backfire on us in various ways, the reality was the Trump ATF tried to do the opposite way. They tried to go through the executive route by how they interpret the statute to encompass and thus ban bump stocks. You can debate the good and the bad of that, but that's, I think, basically what happened here. So now we're in front of the United States Supreme Court, and today was a huge fight about statutory interpretation. Let me cut to the chase, though, on some big things. The bottom line is that the three liberals, no surprise here, Judge Kagan, Judge Sotomayor, and Judge Brown Jackson, are utterly hopeless on the gun issue. They're absolutely terrible. The fact that it shoots means we're going to lose, so there's no way we're going to win those three justices. It's game over. Don't even worry about that. We're going to lose them. So the question is, what about the other justices? Well, on the good news front, I think that Justice Alito and Justice Gorsuch are both strongly in the camp that bump stocks are not covered by the statute. Justice Alito specifically had a detailed discussion about the difference between a semi-automatic firearm, a select fire machine gun like an M4, and a fully automatic firearm like an M16 without a select fire button and all this sort of things, or switch. So he clearly understood this. Justice Gorsuch was literally making fun of the government lawyers, saying, how are people even going to know these things, or machine guns or dangerous devices or illegal or any of this stuff? I mean, are they really, he literally said, are they literally going to read the Federal Register at home in front of a fireplace with their family dog? That's absurd. So it seems to me that both Justice Alito and Justice Gorsuch are clearly in the Second Amendment camp on this issue, even though when I say Second Amendment camp, there is no Second Amendment issue. This is about a statutory interpretation of whether or not a bump stock is a machine gun under federal statutory law. Specifically then, I think we move on to Justice Barrett and Justice Thomas. What's interesting is Justice Barrett specifically said that she had watched all the recommended videos in the briefs about how bump stocks work. So I give her credit, and she was really trying to understand how this worked. And I think she did get the fact that these weapons are not automatic. If you put a bump stock on a semi-automatic rifle, it doesn't make it an automatic firearm, as you know, because you still have to engage in manual manipulation. You not only have to hold the trigger down with one finger, of course, you also have to, with your other non-shooting hand or non-trigger hand, hold the forearm, if you know, forward, right, and get that rocky motion going. Justice Barrett seemed to get that, which I think is very positive, and we'll talk about some grammar issues that she raised. I think is very good. Justice Thomas asked some quizzical questions, which I think he's going to rule in the right way, but even there, I couldn't tell whether or not he was asking difficult questions of the lawyer for Michael Cargill about bump stocks because he was playing devil's advocate and wanted to see what the answers were for potential opinion, or if he truly thought that maybe you can ban bump stocks as a machine gun. So I would say we clearly have Justice Alito and Justice Gorsuch. I think we probably have Justice Barrett and Justice Thomas. As to Justice Kavanaugh and Justice Roberts, I think they both could go either way. Obviously, if we lose both Kavanaugh and Roberts to the left, then bump stocks will be viewed as a machine gun. Now, the good news is Justice Kavanaugh clearly expressed repeatedly concerns about how is this fair to ordinary Americans? How will they have notice? What would the knowledge be? I mean, how will they know that these are machine guns, these devices? And he clearly had concerns about how fair this was, especially, and I think he specifically mentioned, how is it possible that you had the Bush administration, you had the Obama administration, you had Democratic senators like Dianne Feinstein all thinking that these bump stocks were not machine guns, and then all of a sudden in 2018 you have this switch. So I think the fact that ATF did this 180-degree switch is the sort of thing that's going to cause them to lose credibility. It's not like this is a long-standing policy of the ATF. They literally switched, and they did so under political pressure. There's no dispute about that. And I think in light of that, I think we are probably going to get, Justice Kavanaugh, and I think we may get Justice Roberts. It's hard to say, but I do think this is going to be a close call, much closer than I would like to see. Now, let me give you a couple thoughts, overall thoughts, and then I'll break down some of the specific statutory arguments. I will let you know right here, I know you're not going to like this, but, it's not my job to talk about rainbows and unicorns and all this stuff on this channel. I'm here to try to tell you what I think is the truth in the world in which we live. It's not the fantasy world or the world I might want to be in. It's the world we're in, and I have to be frank about that. In light of that, it is crystal clear to me, and I know you're not going to like to hear this, but I think it's a fact. I do not see that this current composition of the U.S. Supreme Court is ever going to find that machine guns are protected by the Second Amendment. There was enough comments there. Even my justices that arguably would be on our side, Justice Gorsuch and Justice Barrett, seem to indicate that they thought that it would be a good idea for bump stocks to be banned and that they could be banned. But of course, their concern was, if you can read between the lines, that Congress did not do it. The ATF, the executive branch, went out and did this. And I think that bothered them. But it does seem to be, by all intents and purposes, they thought it would be a good policy idea to ban these devices, probably because they view that if you ban machine guns, or tax them, excessively under the NFA, but you allow people to have bump stocks, it's almost like a workaround or a circumvention here. And I do think that's something that these justices are looking at. Now, with that said, I think if you push me, I would predict it's going to be a narrow win. It's going to be a close call. We could certainly lose this case. I do think there's a real chance, maybe 70-30 or 60-40. There's at least a real legitimate chance that we could lose this case and they could find, as a matter of statutory law, that a bump stock is a machine gun. I do not think that's the right answer, and we're going to get to why in a second, but I do think that is a possibility. I think part of the problem here, and we're going to have to think about ways to dealing with this going forward, is that the justices, even though they are smart people, they have smart clerks and whatnot, I did get the sense that they were struggling a little bit with understanding firearms technology, understanding the bump stock technology, understanding how all this worked. And I do think that that was a negative. The one person who clearly understood firearms technology was Justice Alito, and he understood it clearly. But I got the sense that the other justices were struggling a little bit. And I think there's something we should take note of in that regard. Now, as to the actual arguments, a couple things that stood out as weird. You and I have talked about, or we have talked about, a couple doctrines. The Chevron doctrine, which is the doctrine of deference that says, when in doubt, you defer to the interpretation of a law, the interpretation of regulation or statute by an administrative agency. In this case, that would be the ATF. The general rule is you defer to them. But that Chevron doctrine is almost certainly going to be wiped out by the Loper-Bright case this term. So it's very interesting that the ATF must have seen that handwriting on the wall. They specifically disclaimed any Chevron doctrine here, any Chevron deference in this case, so it did not even really come up in any respect. So that's by the wayside. So they either have to win on the statute or they're going to lose when it comes to the perspective of the ATF. Now, the next thing that I thought that was interesting, that I thought was going to come up but did not come up, is what's known as you know, the rule of lenity. The rule of lenity. The rule of lenity is where you have two reasonable interpretations that are kind of polar opposites or disconnected or different from each other. Two reasonable interpretations that come to opposite conclusions. That means that that document, or in this case, the statute, is ambiguous. Here, the question is the statute ambiguous as it applies to bump stock? Specifically, what does single function of the trigger mean? The government is trying to argue that a single function of the trigger is you have a shooter that holds the trigger down and is just holding the trigger down. And as a consequence, the shooter has a single function of the trigger by pulling it. However, the lawyers for Michael Cargill, who did a good job arguing this, said that no, that if you look at the words of the statute, single function of the trigger is talking about an object, is talking about an inanimate object, and the function of the trigger refers to the internal operations of the gun. So you see what I'm saying here? This is a very technical argument today. It wasn't the grandiose theories of constitutional law or anything. It was really very specific of is the statutory language of that a single function of the trigger causing the firearm to automatically shoot more than one shot. Is that phrase single function of a trigger refer to the internal operations of the gun? Because the argument from the Michael Cargill lawyers, who's the plaintiff here, says that just because you're holding down the trigger, the internal operations of the gun is still semi-automatic. That they're going through the auto sear, the disconnector, the hammer, if you will, are going through their normal semi-automatic exchanges and processes, and there's no difference. And simply adding a bump stock on that doesn't change that internal operation or that internal function of the trigger, and therefore it's not, the bump stock doesn't convert a semi-automatic firearm into an automatic weapon. In contrast, the Biden Department of Justice was arguing that the single function of the trigger means that the shooter pulls the trigger, and that is a single function of the trigger. And there's a lot of debate about, do people function in that sense versus the object of a lot of grammatical arguments in this regard. We'll get into that in a separate video, but the bottom line is, I think grammatically we have the better argument. But again, the reason why I bring up the rule of lenity here is to the extent there is equipoise or equally different views, meaning the shooter is causing the single function of the trigger on the statute, or the gun's internal operations constitutes a single function trigger. Whether it's one or the other, argument is ambiguous. And because it's ambiguous under the constitutional rule of lenity, that means that the winner is the citizen and the government loses. So one thing that stood out here was the dog that did not bark. There was not a lot of discussion of the rule of lenity, which kind of surprised me. And that tells me that this court is trying to just outright interpret the statute and yay or nay whether or not a bump stock falls under the definition of machine gun or it does not. Okay, so the final point I want to make here is there was no discussion of dictionaries. This is very interesting because the conservatives on the Supreme Court are really hyper-textualists, meaning they really look at the text of the Constitution, they look at the text of the statute and try to say, what does the text mean? What does every word mean? In other words, they're not just trying to talk about airy-fairy spirit of the statute. They want to say, what does the actual words mean? Legislative history doesn't count. They want to say, what does each word of the statute mean in this context? But in contrast, the left-wing justices here said basically that, hey, it's just common sense. This is what Congress is trying to ban, things like machine guns, so it's good enough for us. We think it should be banned. But the textualists, the conservatives, are trying to really understand, what do these definitions mean? But in light of that, there was no discussion during the oral argument of dictionaries. Dictionaries are usually a very good source for defining terms, but none of that came up today. So the rule of lenity I thought was going to come up quite a bit, didn't come up at all. And also the use of dictionaries, which I thought was a favorable thing for the Second Amendment movement for Michael Cargill's lawyers, didn't come up at all. And last but not least, there was some discussion of legislative history, but the good news is this, that legislative history, I think, doesn't actually help the NFA people, the government here, and it was basically discarded pretty quick. The only other thing I will mention, it's pretty clear where the Biden administration, the government, and the liberal justices want to go. They want to somehow redefine the National Firearms Act's definition of machine gun to include rate of fire. They want to say that any item, any object that makes the rate of firing of a semi-automatic firearm go faster somehow makes that gun now a machine gun under the National Firearms Act. And again, it's pretty clear that that rate of fire language is not in the statute of the National Firearms Act, and that was admitted to, by the way, by the government's lawyer, who basically said, yeah, rate of fire is not part of the definition of machine gun in the statute, but he still, of course, tried to argue around it in various ways. But I don't think they're going to be able to get there. So anyway, overall, I would say was an average day for the Second Amendment. I cannot say this was a great day. I think there's a chance we could lose this case. I still think we're going to pull this out. I still think we're going to win this case. And if we lose this case, I think it'll be on narrow grounds. It would be very bad, but not catastrophic. But again, I think we will pull out a win in this case. I'm not sure it will be as big as I would have liked, but on the other hand, it's just hard to tell, because the reason why I'm not sure about this is Justice Roberts said very little, and he is one of the swing votes on the court, and I thought Justice Kavanaugh seemed sympathetic to our side, but he really did not overly commit. So, and Justice Thomas, I did not think was as powerful in support of, this sort of angle of, you can just wave a magic wand if you're the ATF and get rid of bump stocks, as I would have liked. But again, it's not clear to me whether or not Justice Thomas sort of believes that you can ban bump stocks under the machine gun law, or if he was, again, just playing devil's advocate. Only time will tell. So that's where we are. We're going to hear a decision probably in June, and we will keep you informed. We'll do more videos here and break it down to help you out, but that's where we are today. So, let's hope it's good news, but I can't guarantee it on this one based on today's argument. All right, there you have it, folks. Don't forget to follow me on X at 4Boxes Diner. By the way, I put out a lot of tweets about this. I live tweeted this, so you may want to check out at 4Boxes Diner, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.